All right, so recording is in process. I'm going to go ahead and share my screen. Okay. And we got the PowerPoint. Look at that. Okay, so this is welcome to our quiz, question and answer session. I'm going to start off by saying that the quiz is still going to be fill in the blank, but it's going to unfortunately look like an essay question. So turns out Moodle cannot allow us to do fill in the blank questions. So what I've had to do, what we figured out, the only workaround appears to be to make it a essay question. Also, if we try to do it as a short answer question, then it gives you kind of the same viewer vantage point that you had when you did the Microsoft Forms earlier in the trimester, and you all couldn't, it was a pain. You could only see a little bit of you could only see a small line, and you had to scroll, and I didn't want you all to have to do that. So long story short, it is going to, your essay question at the end is going to look the same question-wise, as far as format-wise, as your fill in the blank answers. It was the best thing we could come up with. So it would, for example, you will have your conveyance, Joe to Tommy, and his heirs. And then you're just going to have a big box at the bottom, and you're going to write. And so at this point, it's not going to automatically grade everything. I'm going to grade them for you. So, it won't, you don't have to write it any specific way. My preference would be if you write it in a way that is easy for me to grade, to say something like Tommy equal or gets an arrow sign or an equal or whatever, and then that he has a fee simple. You will no longer have to write that Joe gets nothing. You will no longer have to write this, because I was going to have you write that before when we were using a fill in the blank model with ExamSoft. But again, we're not using ExamSoft because I know some of you have used electronic notes, have typed up your notes, and you may not have access to a printer. Also, I don't want those of you who have access to 2 computers to be advantaged over those that only have one, because you could ostensibly do a find and search for something if you have access to computers. Anyway, the only way I could come up with evening the playing field was to let you use Moodle to take the quiz. Moodle does not let you use fill in the blanks. So again, you're just going to have a conveyance like this, and you're going to tell me what the interests are. I don't need to see your work. The box is going to be bigger than what you need to write in, but at least you'll be able to see all the words that you type in. So this is the best we could come up with. I am going to verify. I have to import everything. Well, I have to figure out if I can import your questions or type them individually a little bit later when we're done with this session. I'm going to do that. So I'll put a post in Teams to verify 100% that it actually worked, and we tested it, and it worked out okay. And I'll verify that with you. Any questions on the format? So you're still going to have the 26, I guess, short answers, and then the 1 essay question with the 2 subparts. Any questions? Feel free to interrupt me. I can't see your hands.
Can we expect to have already been added into the Moodle course?
Nope, I haven't added you in yet because you're already in. I just have to make it live. So I will do that as soon as I have finished cleaning up both of the courses because essentially it puts in a bunch of junk in there. And so I have to delete everything, but it does. So I will do that. So, and then I'll make it live. So that all going to happen by this evening, and I'll send you an email so you can test out, or I will post in Teams so you can test out to make sure you have access to Moodle. But thank you for that. That's a good. I'm gonna make a note to myself to send you that email. All right. But yes, you do not see the course right now because it has a bunch of extra stuff in there. Like it has 10 topics listed that have nothing in them. So confusing. Good question. Any other questions? All right. Seeing none, let's start talking about the rule against perpetuities. Before I get into the details, I first want to say that the rule against perpetuities is a very difficult rule to wrap your head around. And so is future interests, estates and future interests. You will see estates and future interests again when you get to wills and trusts. It is a difficult concept. Even law professors have a hard time grasping wrap, and they often give me funny faces when I tell them that I'm going to teach wrap that day. So you are not alone. Everybody finds it difficult. The only way that you learn it is by doing the problems multiple times if necessary to get them. I strongly suggest you do your workbook problems. I have found that the way the workbook presents it is the easiest way to grasp, but again, everybody learns differently. So I have given you different additional, you have been able to see the way that Callie explains it, and we did some thinking over the last couple of days over how if I could present it in another way that might help you grasp it. So here are some tips, I guess, some ways to approach wrap that hopefully will clarify some of the questions that you have. Okay, so no interest is good unless it must vest, if at all, no later than 21 years after some life and being at the creation of the interest. Very complicated wording. So let's dissect this. So first, let's pick it apart. The first thing, it says no interest is good. All right, what does that mean? Well, that's telling us that the interest, if it violates this rule, will be void, right? So that's all that's telling us. Then it starts off with the requirements. It must vest, and it must vest no later than 21 years after some life and being. You'll see why I'm breaking it down like this in a minute. After some life and being at the creation. Oh, I should use a different color of the interest. That's all right. Okay, so let's define these concepts. I think that would help. So we said this just means that the interest, this here means that the interest is void, right? If it violates the rule against perpetuities. Now, you can translate this rule to saying that an interest must vest within 21 years of, it's called a measuring life, or life and interest, whatever makes sense to you. So that's really what the rest of this is saying. And we're going to break that sentence apart even further. But we know right away from this sentence, the interest must vest within 21 years of a measuring life, that this is only going to apply to interests that have not completely vested already, right? So interests that have not completely vested are contingent remainders, executory interests, and vested remainders subject to open. Now, vested remainders subject to open are, it's a little bit confusing to grasp. You can also think of them as vested remainders subject to partial divestment. That might help. Your workbook does mention that definition, and the Cali lesson focuses on the definition. And the reason they do is because it might make more sense to you, right? So if you think of it as a vested remainder subject to partial divestment, it means that part of the interest is already vested, right? There is at least one ascertainable person that has a absolute interest in the land or in the real property, right? But it's subject to divestment because their interest could become less. Meaning, if more people are added to the class, then they're going to have to share their interests with other people. Okay. So we have translated wrap into maybe a little bit of a more graspable sentence. We've said that we're only going to worry about wrap if we have one of these three interests right here. But what do these words mean? These words are complicated and confusing, and even the workbook authors, when they define these words, they sometimes use the same word in the definition of the word. So it goes to show you they're difficult to define. So let's start with the word must. What does must mean? Okay, you might think, I know what must means, Dr. El-Sabawi. Yes, you do. But in property, remember, we don't use the normal definition of a word. So must, in this context, means that there is no possible chance that it could vest. So no possibility that it doesn't vest. Or sorry, there's no possibility that it does not vest. Yes. There's no remote possibility. And here we're going to actually ignore science or logic. All right. We're going to pretend that you are a paranormal science fiction or fantasy fiction author. All right. So as long as there is some possibility, even if it involves aliens, probably not to that extreme, but you get my drift, right? We can have 99-year-old women having babies. We can have, you're going to ignore what science says or what logic tells us. So that's what you need to know about the word must. Now let's go to the word vest. Vest is a very difficult word to grasp. I looked up a whole bunch of different definitions this morning, and then I came up with my own, but I'm going to read to you what some of the other definitions were of vest, in case one of them resonates with you better than the definition that I came up with. Okay, vest, one commentator defined it as to give immediate, fixed right of present or future enjoyment. So it gives immediate, fixed rights present or future enjoyment. Another commentator defines it as an interest vests when it is secured. An interest vests when it is secured. And this is one of those definitions that's using the word in the definition, but it is what it is. Another commentator described it as when a beneficiary or transferee is certain to receive a specific thing now or in the future. When a beneficiary is certain to receive a specific thing now or in the future. And the last definition I found was an absolute right to present or future enjoyment. An absolute right to present or future enjoyment. So what do all those definitions have in common? Well, when an interest vests, there is a guaranteed right. A guaranteed right. And no conditions need to occur before the transferee has that right. So it's a guaranteed right. So that means no conditions need to occur before the beneficiary has that right. And there is no confusion or uncertainty about who gets the interest. We can name all of the individuals that get the interest. I'll repeat that again. In my view, what all of those definitions have in common is that they discuss a guaranteed right. It's guaranteed because no condition needs to occur for the transferee to have that right. And there is no confusion or uncertainty about who gets the interest. Okay? Any questions on the definition of must or the definition of vest? All right, seeing none.
I've got one question. This is Jacob.
Hi, Jacob.
And Callie, it was talking about how a lot of times, I want to make sure I have this clear. It talks about how we need to be very careful that just because something is not vested doesn't mean you don't have a right in it. So it kept talking about the time to actually enjoy the property.
Yep.
So if you have a contingent remainder, let's say, you have a right to that interest, but you will not possess it until you meet the stated condition, correct?
Correct. So thanks for bringing that up. So let's talk about, so you can have a right. One way to think about it is that if you have a present right, a present interest or present estate in the property, that means you both have the right of enjoyment, right? So you have enjoyment and it's present, it's now, right? Enjoyment, possession. So with the future interest, you kind of have two rights. You have the future interest itself, just knowing that you're going to have something in the future. And then at some point, you will have the ability to possess. So it's deferred possession. So sometimes complicates it a bit, but this is a more accurate way to view it. You can have a vested future interest, but the right to possess has not vested yet.
Okay. Yeah. Okay.
So what we say, so a vested right to possess. RAP is not worried about this second part. Wait, hold on. Let me double check. I was getting confused. I don't want to confuse you all. Yep. So RAP doesn't care about this vesting because this part vests when, so let's say, let me give you an example. This is going to be the best way to explain A to B in life, then to C. Okay, so we know B has a life estate, right?
Right.
C has a vested remainder.
Be simple.
Be simple. Okay, so this is vested even though C doesn't get possession of it until B dies.
Right.
So what are we talking about here? We're just talking about the interest for future. He has a future interest, and that future interest has vested. Meaning there are no conditions on it, and this person is ascertainable. But unfortunately, because in property we like to make things super confusing, we use the same word, vest, when we talk about the possessory interest. So then we could say C's possessory interest doesn't vest until the previous estate is complete. So do you see how vest can be used? It's a verb. There is a condition that must be met before C can take possession, and that condition is that B's estate has to be done. But for RAP, we don't care about possession. We don't care about actual possession. We just care about when this future interest is going to vest.
Yeah, that makes sense. This rule's crazy.
It is. It is a
We
crazy
need to
rule.
get rid of all the interests that applied to this rule, and that way we get rid of the rule itself.
Yeah, well, and the unfortunate part is because Professor Hiley says he doesn't spend a lot of time teaching RAP because it's rarely tested in the multiple choice for property. And my answer was yes, but it is commonly tested in wills and trusts. So this rule comes back again to haunt you in wills and trusts. So it is, yeah, it's a crazy rule. But if you're a bar examiner and you're looking for a hard question,
This is your place to go.
I would say so. But yeah, I don't know that it's tested a lot in the multiple choice or on the property essay. But if it is tested, it's one of those things that you want to know it because it's not easy to guess.
True. All right. Well, I appreciate you answering that for me. I just wanted to be sure I had all those vested rights and interest and all that sorted in my head.
Yeah. So when we're talking about conveyances, I guess, I tried to find a way to not confuse everybody and still talk about the difference between possession and just the interest itself, or an interest in interest is what they call it, which is kind of like, it's not very. And I guess the only way to do that is because future interests do become possessory estates, right?
Yes.
Right. And so once it becomes a possessory estate, then the possession is vested.
But you have a vested future interest when right after the previous estate runs out, there's nothing to stop you. You're identified and you can just go ahead and claim that immediately.
Correct.
Okay, that's how I'm gonna just have to remember it. It just has to be off the rip. I can walk up to it and it's mine.
Right. There are no conditions that bar you from taking the property except the expiration of the previous estate, right? So we have to wait
Right.
till the life estate's over, and
Right.
then,
Okay. I appreciate that. Thank you so much.
yeah, I hope that clarifies it.
Oh, it does. I'm good. I appreciate it.
Okay, good, no problem. Any other questions?
Yeah, Professor El-Sabawi, it's Megan Riley Dries. So, hey, so I just want to make sure that I'm understanding this. In this scenario that you gave, where you said A to B in life, then to C,
Mm-hmm.
C has a vested remainder in fee simple, correct?
Mm-hmm.
Okay, so, so to have a vested interest, it has to be true that interest isn't conditioned on anything, right?
Anything except the expiration of the previous estate.
Okay, yeah. So, but okay.
I know, which
It's
is
a little
why
bit backwards, right? Because you're saying it's vested, but there is a condition. So is this the only situation wherein
well,
you have a conditional vested interest? I don't know.
no. You can think of it this. It depends on how we want to. Okay, you can say yes. There is no condition for the future interest.
Mhm.
Okay, so
Mhm.
we say when we say it's a vested remainder, what we mean is there is no condition that needs to happen for C to have a future right.
Okay.
Does that make sense?
Yeah, the use of the word right helps that make sense to me.
Okay, a future right to
Right.
possess. Okay. Now, does a condition have to be met for him to possess it?
Yes.
Yeah, because he doesn't have a present possessory interest, it's a future interest.
Okay.
All right.
Yeah, thanks for clearing that up.
I hope I cleared it up and I didn't confuse people more. I know it's you just got to keep doing the problems and keep talking it out, and hopefully one of the ways that somebody presents it, it'll sink in. All right. Any more questions before we move on? All right. So let's move on to what is a measuring life, or what is this after some life and being at the creation. I call that a measuring life. It can be called a life and interest, or what does your workbook call it? It calls it lives in being. Whatever works for you. All right. So I don't only call it measuring life. There's other books that call it measuring life. I didn't come up with this. So, let me not take credit. So measuring lives. It is difficult to identify measuring lives. It is a source of confusion for many in property and in wills and trusts. Here is the simplest way that I have been able to come up with to explain it. Hopefully it will make sense. Okay, A. One category is an actual life. Wait, sorry, you have to break this up into two. I forgot how I did this. Okay. You have to break this up into two components. First, you question whether the life is in being. And then your second question is, was it in being at the creation of the interest? Okay, why are these two different things? Because for B, if a conveyance is an inter vivos conveyance, meaning that it is that when conveyed when the transferor is alive during lifetime, that's what inter vivos means. vivos life. If it's an inter vivos conveyance, the interest is created at the conveyance. Okay? The deed being handed over or the property being handed over. If it is a testamentary conveyance, a testamentary conveyance is a conveyance through a will or intestate after somebody has died. That's the key. A testamentary conveyance is after somebody has died. Then the conveyance is not when the instrument is drafted, so not when somebody writes their will, but upon death. So why does that matter? Well, for the purposes of your exam, I'm making it simple, and I am saying all conveyances on this exam are inter vivos conveyances. So all of them are going to be at the actual, we're going to assume that when I say A to B, that means that there was an inter vivos conveyance and the deed was given to B. But in your workbook, it made the distinction between an inter vivos conveyance and a testamentary conveyance. And when you go take wills and trusts after this course at some point, or if you get this, you get a question like this on the bar exam, the interest is not created until death. And so when you're applying RAP, you look at the date of death of the transferor to see what lives are in being. Whereas for an inter vivos conveyance, you're just looking at the date that the deed is handed over or the conveyance is written. Okay? Questions on that? I just want to clear up confusion that you may have had by doing the problems in your workbook. But on the exam, I'm not going to test that difference. And I'm going to put in the instructions that we're going to assume everything is an inter vivos conveyance.
I have a question.
Yes.
So you don't have to wait for the 21 years to pass, right? You determine whether or not it would be at all possible or logical for it to vest within those 21 years. And if it's not possible, then it's void upon creation of that clause.
That is correct. So we're going to talk about that. We're going to walk through a problem and we'll do, yes, that is correct.
Okay, thank you.
Yep, you don't have to actually wait and see unless you're in a wait and see jurisdiction. But I am not on the exam. We're going to assume that we're in a jurisdiction in which the rule against perpetuities applies and there are no modern rules. I'm also putting that in the instructions to make it simpler. Okay. So let's talk about life and being. How do you know what lives there are? Well, let's see, what is the little test I came up with? All right, so two categories of folks. Either people that are actually named in the conveyance. Second category are people that are implicated in the conveyance. The first part is pretty easy. You just go through and everybody that is named, including the transferor, is going to be one of the named people, right? So if we have A to B for life, then to B's children, Then we know named is going to be A, B, and that's it. Right? Those are the only ones named. Implicated. Well, to understand what implicated means, the best way I could come up with defining it was, if you have a class gift and there are class members that are alive at the creation of the interest, then they are implicated. What do I mean by that? Well, let's take the same problem we have here. And let's say that instead we know that B, at the time of the conveyance, has 2 children, Tom and Jerry. So a class gift, this is a class gift. Remember, it's a gift to a category or a group. It doesn't have names. Okay. Class gift, and the class members that are alive at the conveyance are Tom and Jerry, so they are implicated. So then it would be A, B, Tom, and Jerry. These are the lives in being. Does that make how to find the lives in being more sense? Does it make it easier to find the lives in being? Any questions on that?
I have a question. This is Sean Jeffco.
Hi, Sean.
Hey.
Go ahead.
So the last hypo that you just did, that was for implicated, or was that for named as well? That was for named as well, is correct?
Well, this is the total answer for 1 and 2. So these were the named
Right.
people, and these were the implicated people.
Okay, that's what I thought. For some reason, I was thinking something different. I don't know.
I didn't specify, so that's probably why it was confusing.
Okay, cool. Thank you.
I've been struggling with technology issues all day with Moodle, and then I have administration hounding me. They keep asking me, well, will the exam be filled in the blanks? Well, how many, have you figured it out yet? No, leave me alone, people. Okay. All right. So do we have? Yeah. Go ahead.
More about this?
Yeah, sure.
So if B has a child after this is all drawn up, and the child is, let's say, like born after B dies, it's Sylvester. He doesn't get anything because he wasn't like in the contemplation of this, because it wasn't a life in being at the creation of the interest.
No, we're just talking about rap right now. So we're looking at for the purposes of rap, not for the purposes of who takes. For the purposes of rap, which are the measuring lives?
Okay, thank you.
Okay. So if B has a child after this conveyance, then that child is called an afterborn child. And afterborn children are not measuring lives. Now, whether or not you're a measuring life has nothing to do with whether or not you take. You can be a measuring life and take nothing underneath in the conveyance. So if it said, for example, A to B, if Sammy passes the bar, right? So Sammy is a measuring life, even if he doesn't take anything from any real property. He has no property interest in this conveyance, right? So he would fall under one of the named people because he's literally named. All right. So measuring life, it's kind of like if you think about how you can have a life estate per autre vie, right? That's somebody is named, they're a measuring life, but they're not taking a conveyance. Any other questions? All right. Moving on. Let's do a problem. This is straight from your workbook, and it is illustration number 5. Let me see if I can find it. Or maybe it's problem number 5. Nope, it's not problem number 5. Okay, I don't know what page number it's on. Apologies, but it's on here, so. All right, so. To Marge, then to Bart, and his heirs. So we have Homer to Marge, life estate, then to Bart in fee simple. This means Marge has a life estate, and then Bart has a vested fee simple. We all follow with that one? Easy problem. It's our warm-up. Do we apply the rule against perpetuities here? The answer is a resounding no. Why? Because we have a vested fee simple. We don't have a contingent remainder or either of the 2 other interests that I listed. So always check to make sure that the rule against perpetuities is implicated. All right. Let us look. Let me make sure that I inputted the right problems. Because again, just 1 second.
Professor?
Yes.
These are on page 53 of the workbook.
Oh, thank you.
Yeah. Because I was just reviewing them.
Okay, thank you. Because I put some in here as warm-ups, and then I forgot how many warm-ups I put in.
Yeah,
Or I
that
mean,
was
how many non-wrap problems I put in. So I'm opened in the workbook to the wrap section, and I'm not finding them. Thank you. I do the absent-minded professor act really well. Okay, problem number 10. The reason I wanted to highlight this problem is I wanted to talk about transferring interests. So here we have Marge has a life estate, or Otreby. Oh, I never spell this right. Poor Otreby. Okay. And Homer has a reversion here, right? So if Marge, she can transfer her interest. Okay. So she sells her interest to Nelson. And then 1 year later, Nelson dies and he wills his assets to Edna. Well, as long as Lisa is still alive during this life estate per Otreby can be transferred all the way over to Edna. When Lisa dies, that life estate ends regardless of who has it, and it goes back to Homer. So this is an example, that's why I put it in here, because this is an example of a measuring life that is still used. Now here, again, wrap doesn't apply, but see how we could use the measuring life of another. The measuring life of somebody who does not have a property interest. All right. This one I did put the page numbers on. And it might not actually be on 243, but let's double check. Yep, this one's on page 243. Okay. This one was confusing to me because Kyle and Kenny. I thought that said Kenny to Kenny the first time I did this problem. So Kyle to Kenny for life, then to the first child of Jeff, who reaches 23. In this problem, Kenny is alive, Chef is alive and has 2 children, Ike, who is 1, and Stan, who is 3. So the first step is to write out the interests like you would with any other problem. In this case, we would say that Kenny has a life estate. Then the first child, who reaches the age of 23, has a contingent remainder in fee simple, and it's contingent because there is this condition, which is that they have to be the first child who reaches the age of 23. And it's a class gift. Well, actually, it's not a class gift. Ignore that last part. Go with the condition. The reversion goes to Kyle because if for some reason one of Chef's children don't reach 23, the property has to go somewhere, right? Reversion, not aversion. So we know that there is already Ike and Stan. So we have Ike and Stan. But because this is a contingent remainder, we're going to have to test to see if RAP applies. Okay, the first step is to list all the lives in being at the time of creation. That would be Kyle, Kenny, Chef, Ike, and Stan. And I just used the little trick that I gave you all a couple slides ago. So those are all the lives in being. Now we need to give birth to some children. We need to have Chef have some babies. Okay. I find it first, let me back up. What I've been doing with these problems, I find it useful to give a pretend date for the conveyance. So let's say this property is conveyed in 2000. And then I write here a list of people that are alive. I found that helpful. Then I would just pick a random date. Let's say that Chef has in 2003 another child named Teddy. And so we give birth to Teddy. Teddy's born. So who are you giving birth to? You're giving birth to anybody that might affect the conveyance. So look for class gifts, and that's who you know that you have to birth. Or people that may need to be birthed in order to have children that will then be in the class gift. So what I mean by that is if the class gift is to grandchildren, you can give birth to another child that is then going to later give birth to grandchildren. You might have to give birth to a couple generations. That's what I'm saying. Okay, so we give birth to Teddy. And then an easy rule of thumb is to just kill everybody that's alive a year after. Everybody that was alive at the time of the conveyance. Sorry, we don't kill Teddy. So everybody that was alive in 2000, just kill them in 2004. Just add on an extra year. We're very vicious in property and wills and trusts. So here, all of these people die. Usually draw a tombstone. Right, so people all die. Okay. Then we also here need to add 21 years because that's when they die. We need life and being, right? So we draw what they call the wrap line and put that over here. So we're adding 21 years. Make sure I get my math right. 2025. So all interest must vest within this timeline. Now, so we gave birth to Teddy here. Let's check to see if Teddy is going to be able to take. So Teddy is 1 here, and he needs to reach the age of 23. So, or I guess we could just add it here. So Teddy won't reach the age of 23 until 2026. So that means that this conveyance violated the rule against perpetuities because it does not vest. Teddy takes over here. He needs to take in the green. So what do we do? Well, we strike the conveyance that violates the rule against perpetuities. Let's do that. A good way to figure out what words go together is commas are very important in drafting contracts. So, and in real property, commas are very important when we do deeds, we write property descriptions, because they tell us what goes together. So we know there's a comma here. We are going to blue line or just cross out this conveyance right here. So that leaves us with Kenny with a life estate and Kyle with a reversion. Now on your exam, this is all I'm looking for. I'm not going to be looking to see if you did all this, because if this doesn't work for you, then you don't have to do it. But I've read a lot of books with rule against perpetuities how-tos, and this by far is the best way I've ever seen that this has been explained. Okay, questions on that question?
I have one.
Yes, go ahead.
So if one of Chef's children, like Ike or Stan, if they died in 2005 instead of 2004, then you would measure from 2005 forward?
You wouldn't measure. It doesn't matter what actually happened. You don't measure when they actually die. Right? We're doing what if scenarios. So if you were, let me rephrase. If you were in a wait and see jurisdiction, yes, they would wait to see the actual date that Ike and Stan died, and they would measure from that date. And they would find that it didn't violate the rule against perpetuities. But we're not in a wait and see jurisdiction. In RAP, we don't wait to see when they die. We just, at the time of the conveyance, if there was any possible way that Teddy could vest, even though he actually would have ended up vesting, in this case, within the period, right? It doesn't matter. What matters is that he could have not vested. Does that make sense at all?
It will once I spend several hours thinking about it.
So we don't care what really happens. What we care is what could have happened. Because we're not waiting to see. Think of it this way. Let's say we're in an attorney's office and we're drafting the document, okay? We're drafting the conveyance. You are then tasked at that point with deciding if there is any possibility. You can't see into the future. You don't know what's actually going to happen. Is there any possibility that Teddy can vest after 21 years of all the lives in being. So think of it like you're doing it at the time that you're drafting it, at the time of the actual conveyance. Does that help? Sure, you can think of scenarios where it would vest, but we don't care if if the probability of it not vesting is only 1 out of a million hypotheticals. The fact that there is that 1 out of the million means that it's going to violate the rule against perpetuities.
Okay, that makes sense. Thank you.
Okay.
I've got one more question. What do we do about Ike and Stan here? So
They don't get anything.
it says Kyle DeKinney in life estate. Then to the first child of Chef who reaches 23. So that's a contingent remainder in fee simple. And then the facts tell me that Kenny is alive, Chef is alive, and Chef has 2 children, Ike, who is 1, and Stan, who is 3. So if I add from the time of conveyance, which is 2000, you add 21 years to that at that point. If any of those do what?
Nope. You got to wait till everybody dies. And you got to have all the afterborn children.
Okay.
Because what if we don't know that Ike is actually going to reach the age of 23? Maybe there's like COVID-20 and half the population, God forbid, or would go back in time when the survival rate of children wasn't very high. We can't assume that the children will actually survive.
Where did 2004 come from? So that's just when we killed everybody.
Yeah, you could put whatever years you want in there. I mean,
okay.
You could do 100 BC. It just helps, in my opinion, to put dates.
Right.
It makes it a lot harder to conceptualize if we're just dealing with, on the line, we're adding it to like A or variables. So I just pick dates.
So the 21 years starts when everybody's dead.
When we decide to kill everybody off, correct. And the rule of thumb is to always kill everybody off a year after you have birthed the appropriate people.
Okay. So you added Teddy into this hypothetical just for this example.
Well, because you're always supposed to give birth to afterborn children when you're doing the rule against perpetuities. Whenever you have a contingent remainder, you check to see if you need to give birth to anybody. Because, see, in this example, Chef can have other children. Like, Chef can have, let's say, Chef has Teddy, Chef has Tommy and Linda, and then, yes, the conveyance says the first child to reach 23, but again, we don't know that Stan is going to be the first child to reach the age of 23. We don't know that Stan is going to survive.
Okay, I see what you're saying now. I think I'm following you now where Teddy and all this comes into play.
Yes. So remember, when a lot of these rules were created, we lived in a time when the survival rate for children was not as high as it is today. And so, go ahead.
Well, I'm sorry. When we're dealing with one of these problems and we're looking to see if RAP is going to apply, we need to birth somebody, kill everybody off a year later. And if that person is birthed, and then after everyone's dead but that one person, if they can't vest in 21 years, we have to pencil that piece out. It violates the rule.
Correct. So let's go through the rules again. So the steps. So first, you identify the interests as you would any other problem. You decide if you have a contingent remainder or an executory interest or a vested remainder subject to open, right? So you identify the interest and then you decide, does RAP even apply? Okay, if the answer is yes, then you continue on. So your next step is you're going to list the lives in being. Then you're going to give birth. By the way, your workbook makes this step 2 here. So if you're wondering, I'm using the same steps they do. I just put 1 and 2 together. All right.
Okay.
So then you give birth to any afterborn children that might affect the vesting. Then you kill off the lives in being. You add 1 year. And draw your wrap line. Back up, just kidding. Give birth, then you add 1 year, then kill everybody off. Long day. Add 1 year, then kill everybody off. Well, not everybody, kill all the lives in being. Be more precise. So we identified the interests. We decided, does a wrap apply? We said yes. We listed the lives in being. Then we gave birth. Remember, these are afterborn children, so they're not a life in being. Remember, these are the lives in being are the ones that were alive during the creation. Mm-hmm. Then we add 1 year to this date from when this person was born. And we kill off all the lives in being, so kill off all number 2s, the ones we listed in number 2. Then we're going to add 21 years. And draw a wrap line. And then the final step is to ask, when will the interests vest? If it's before the wrap line, we're good to go. We didn't violate the rule. If it's after wrap line, then we violated the rule.
Okay.
And then we cross out the conveyance. Okay.
I just know. I just can already tell Wednesday. Not that I don't understand this, but I'm gonna get into a problem, and it's gonna be one of the types that this applies to, and I'm just gonna completely forget about doing this. I don't know. I'm just gonna struggle. I can just already tell.
Well, take a Post-it note. It's open book. Take a Post-it note. Write the 3 different the 3 different interests that wrap triggers, and stick it on your computer screen. All right.
Yeah, I'm actually going to do that.
All right, there you go. We do what we got to do. There you go.
I appreciate that. Thank you.
Yeah, no problem. I wanted to just go, I know our time is short, so I just wanted to go over one more that somebody had a question about, and it's how do we strike interests? What's the difference between, a fee simple? How do we strike interest when we have a fee simple subject to an executory limitation? Because it actually is going to depend on the language. Even though these two, so let's say for both of these cases, both of these examples, wrap applies to 1, wrap applies to 2. Now we're all the way at the end of our analysis, and we're trying to decide, great, what do we blue pencil out? So here is, remember I told you punctuation is very important in property law. Here's where the punctuation matters. So it does have to do with the language, right? So if we have words of limitation, right? Words of limitation are as long as, until, during, or while. Then this language here, this condition, is part of the previous estate. And that's not what we scratch. It's not what we blue line out when we cross out an interest that violates RAP. We're crossing out this interest. And so a trick is you can look to see where the comma is. In this example here, we have the words of limitation here are provided that, or but if, provided that, on condition that. And the comma is right here. So when we're looking to see where the condition falls, you're striking the condition. You're only striking conditions if they are a part of the interest that violates, which would be this part. So in this case, we would scratch this out. So I find the comma rule pretty helpful, personally. Okay, so when you have an executory interest, look to see where the conditional language is. If it's durational language, like this, it's gonna stay because durational language is placed, again, comma, placed with this first conveyance. Whereas if you have other type of language, which I'm blanking on the name of right now, durational language.
Do you mean conditional?
Conditional, thank you, yes. I'll tell you guys a funny story in a minute. But yes, if you have conditional language, then the comma goes before the conditional language. And so that conditional language is actually placed with this interest here. And that is, we always strike this second interest that violates RAP. Does that clear that up? All right, seeing as there's no questions, I'm going to assume the answer is yes. My funny story was that I was on the phone with Dr. Carroll the other day, and we were talking about data sets that SAMHSA had, the Substance Abuse Mental Health Services Administration had released. And I kept referring to something as a cookbook. My brain was so fried. I kept saying cookbook, cookbook. And then Dr. Carroll got to her computer and she was like, I'm looking for a cookbook and I don't find it. Oh, do you mean the code book? I was like, oh yeah, totally meant the code book, not the So my brain has been very fried lately and I'm losing words. Hopefully I didn't lose too many and you all understood most of that presentation. Do we have any more questions before I end this? Now I'm still available to answer questions. So if you want to make an appointment, if you still don't get it, I think you need to make an appointment 12 hours ahead of time, but if not, I still have availability tomorrow, so you can email me if you need to, and we could set up a time to talk. But any other questions before I officially end the session? I think that if you all focus on the workbook and you keep reviewing the workbook problems, as I've said before, and you're doing well with the workbook, then you're going to be fine. You also need to review adverse possession too. Don't forget that we went over adverse possession. I am not going to be testing public policy arguments. I'm not going to ask you to make public policy arguments, so you don't have to worry about those, but you will need to understand adverse possession as well. All right. If there are no questions, then let's go ahead and end this session and you guys study. What to do? Hey, Monica, are you still on here?
Yes, I am. Hey,
Okay.
Dr. El-Sabawi.
Hey, hi, Erin. So it looks like my screen is frozen. I'm going to try to log in on their computer because I'm afraid if I just restart the app, it's going to mess up the recording that's in progress. So I can't end the recording. Hold on. Let me see if I log into my. Oh, boy. Let's see. Laptop on computer. What a mess. Right. Okay.